This training presentation is intended for Humane Society of Broward County employees and covers HSBC's whistleblower policy. Please note that the Humane Society of Broward County will be referred to as HSBC throughout this presentation. What is whistleblowing? Whistleblowing in its most general form involves calling attention to wrongdoing, typically in order to avert harm. Whistleblowing is an attempt by a member or former member of an organization to disclose wrongdoing in or by the organization. The topic of whistleblowing continues to be an important and challenging business ethics issue for society. According to the Ethics Resource Center's 2013 National Business Ethics Survey, it found that while 41% of employees witnessed illegal or unethical misconduct during the previous year, 37% did not report it. The range of illegal and unethical activities that goes unreported is extensive and includes corruption, bribery, receiving and giving gifts and entertainment, kickbacks, extortion, nepotism, favoritism, money laundering, improper use of insider information, use of intermediaries, conflicts of interest, fraud, aggressive accounting, discrimination, sexual harassment, workplace safety, consumer product safety, and environmental pollution. According to the study, whistleblowing tips were the primary form of detection, followed by management review and then internal audit. The major source of whistleblowing tips were from employees, followed by customers, and then by anonymous sources. Tips have been consistently by far the most common detection method. The following is a definition of a whistleblower. According to the Whistleblower Protection Acts, a whistleblower is an individual who reports information he or she reasonably believes evidences a violation of any law, rule, or regulation, gross mismanagement, gross waste of funds, abuse of authority, and a substantial and specific danger to public health or safety. A whistleblower, as defined by HSBC's whistleblower policy, is an employee or volunteer of the Humane Society of Broward County who reports an activity that he or she considers to be illegal, misconduct, or dishonest to one or more of the parties specified in this policy. The whistleblower is not responsible for investigating the activity or for determining fault or corrective measures. Appropriate management officials are charged with these responsibilities. In order for a person to obtain protection under the Whistleblower Acts and policies, that individual does not have to be correct in their allegations. Their belief, however, is measured by what is considered to be reasonable. So what is considered to be reasonable? Reasonable belief generally means that a disinterested observer with knowledge of the essential facts known to and readily ascertainable by the employee or applicant can reasonably conclude that the actions of the agency official evidence such violation, mismanagement, waste, abuse, or danger. This standard excludes rumor, speculation, and nonspecific allegations. Something the whistleblower knows is untrue is not protected. An unreasonable belief is also not protected. So basically, would a reasonable person not involved in the situation, knowing the same information and facts, believe that a wrongdoing occurred? So who's protected under the Florida's Whistleblower Act? The Florida Whistleblower Act protects employees and persons who disclose information on their own initiative in a written and signed complaint, who are requested to participate in an investigation, hearing, or other inquiry conducted by an agency or federal government entity, who refuse to participate in any adverse action prohibited by the whistleblower laws, who initiate a complaint through the whistleblower's hotline or the hotline of the Medicaid Fraud Control Unit of the Department of Legal Affairs, who file any written complaint to their supervisory officials, or employees who submit a complaint to the Chief Inspector General in the Executive Office of the Governor to the employee designated as Agency Inspector General under Statute 1112.3189, or to the Florida Commission on Human Relations. So what is considered misconduct? Let's go over some explanations and examples. A violation of any law, rule, or regulation is considered misconduct. This is defined as not something that a reasonable person would consider arguably minor or inadvertent mistakes in the conscientious conduct of assigned duties. Substantial and specific danger to public health or safety is also considered misconduct. This is considered the likelihood of harm resulting from the danger, not whether the danger could only result in harm under speculative or improbable conditions. The key note here is that not mere speculation that it is possible for some danger at some point in the future. For example, let's say that an employee disclosed that an agency lacked ammunition and instructed their security staff to carry weapons that were not fully loaded. Allegation was that the lives would be at risk if the agency was attacked. The danger, however, was too speculative and was not imminent. Gross mismanagement and gross waste of funds are defined as not merely a difference in opinion on how a program should be run. It affects a department's ability to accomplish its mission, creates a substantial risk of significant adverse impact on the department's ability to accomplish its mission. For example, spending thousands of dollars for a database system that basically provides the same information as an existing system. Abuse of authority is defined as an arbitrary or capricious exercise of power by a federal official or employee that adversely affects the rights of any person or that results in personal gain or advantage to himself or to preferred other persons. Examples include harassment or intimidation of other employees, providing preferential treatment to an employee with whom the supervisor was perceived as having an intimate relationship. There are both state and federal laws that protect whistleblowers from retaliation by employers. Retaliation occurs when an employer takes an adverse action against a covered individual because the employee engaged in protected activity. Florida Whistleblowers Act states, an agency or independent contractor shall not dismiss, discipline, or take any other adverse personnel action against an employee for disclosing information pursuant to the provisions of this section. An agency or independent contractor shall not take any adverse action that affects the rights or interests of a person in retaliation for the person's disclosure of information under this section. The provisions of this subsection shall not be applicable when an employee or person discloses information known by the employee or person to be false. The law states that retaliation or adverse personnel actions may not be taken against someone for filing a whistleblower complaint. Here are just a few examples of adverse personnel actions: firing or laying off, blacklisting, demoting, denying overtime or promotion, discharging, disciplining, denial of benefits, failure to hire or rehire, intimidation or harassment, making threats, reassignment affecting prospects for promotion, reducing salary or benefits, reducing pay or hours, suspension, or any other significant change in duties, responsibilities, or working conditions. If an employee chooses to file a retaliation claim against an employer, that employee must show the following. They must show that they made a protected disclosure, that that protected disclosure was known by the employer, and that the employer took an employment action adverse to the employee, and the disclosure was a contributing factor in the employment action. Let's make sure that you as an HSBC employee understand our whistleblower policy. Please note that the whistleblower policy also applies to board members, directors, officers, and volunteers in addition to HSBC employees. Also note that in our policy, the term company refers to HSBC. This whistleblower policy outlines a procedure for employees and volunteers to report actions that an employer or volunteer reasonably believes violates a law, rule, or regulation, or that constitutes fraudulent accounting, misconduct, or other unlawful practices. This policy applies to any matter which is related to the company's business and does not relate to private acts of an individual not connected to the business of the company. This policy is intended to encourage and enable employees, volunteers, and others to raise serious concerns internally so that the company can address and correct inappropriate conduct and actions. It is the responsibility of all board members, directors, officers, employees, and volunteers to report concerns about violations of law or regulations that govern the company's operations. The reporting responsibility section of the HSBC's whistleblower policy explains the reporting process. If an employer or volunteer has knowledge of or a concern of illegal, misconduct, or dishonest fraudulent activity, the employer or volunteer is to contact his or her immediate supervisor. If the employer or volunteer does not feel comfortable reporting the information to his or her supervisor, or is dissatisfied with his or her supervisor's response, then the employer or volunteer is expected to report the information to the Human Resources Department. Supervisors and managers are required to report complaints or concerns about suspected ethical and legal violations in writing to the company's Human Resources Department, who has a responsibility to investigate all reported claims. The employee or volunteer must exercise sound judgment and act in good faith to avoid baseless allegations. An employee or volunteer who intentionally files a false report of wrongdoing will be subject to disciplinary action up to and including termination. Confidentiality. In conducting its investigation, the company will strive to keep the identity of the reporting individual confidential to the extent possible, consistent with the need to conduct an adequate review and investigation. The reports of violations or suspected violations will also be kept confidential to the extent possible, consistent with the need to conduct an adequate investigation, to comply with the law, and to provide the accused individuals their legal rights of defense. Handling of reported violations. All reports of illegal, misconduct, and dishonest fraudulent activities will be promptly submitted to the Human Resources Department, which is then responsible for investigating and coordinating corrective action. The Human Resources Department will notify the person who submitted a report and acknowledge receipt of the reported violation or suspected violation. All reports will be promptly investigated, and appropriate corrective action will be taken if warranted by the investigation. The anti-retaliation clause within the HSBC whistleblower policy states, the company will not retaliate against the whistleblower. No person entitled to protection shall be subjected to retaliation in the form of intimidation, harassment, or adverse employment actions such as termination, compensation decreases, or poor work assignments and threats of physical violence. Any whistleblower who believes he or she is being retaliated against must contact the Human Resources Department immediately. The right of a whistleblower for protection against retaliation does not include immunity for any personal wrongdoing that is alleged and investigated. Any individual within the company who in management's assessment has engaged in retaliatory conduct in violation of this policy against another individual who has reported a violation in good faith, who in good faith has cooperated in the investigation of a violation, is subject to disciplinary action, including termination of employment or volunteer status. Supervisors will be trained on this policy and the company's prohibition against retaliation in accordance with this policy. The HSBC whistleblower policy will be disseminated to HSBC employees and volunteers. A copy of the policy will be provided to all new hires and current staff. A signed acknowledgement receipt will be required to be submitted to the HR department. The policy will also be uploaded into the Timesheet Plus system, where all staff can access at any time. The dissemination and implementation of policy, as stated here, requires that the company shall adopt procedures for the implementation of this policy. which may include training records, documenting reported violations, working with legal counsel to decide whether the reported violation should be directed to another person or department, keeping the board of directors, audit committee, or other applicable committee informed of the progress of the investigation, interviewing employees, requesting and reviewing relevant documents and/or requesting that an auditor or counsel investigate the complaint, and preparing a written record of the reported violation and its disposition to be retained for a specific period of time. The procedures for implementation of this policy shall include a process for communicating with a whistleblower about the status of the report, to the extent that the whistleblower's identity is disclosed, and to the extent consistent with any privacy or confidential limitations. Don't forget that all employees have access to the HSBC Whistleblower Policy and Retaliation Claim Form within the Timesheet Plus system. Simply go to Our Company, Documents, and search for the Human Resources category. Or you can simply obtain a copy from the HSBC HR department. Should you have any questions regarding our whistleblower policy, please make sure to contact the Human Resources Department. Our contact information is listed here for your information.